Okay. Um, so I guess this is the third official meeting. Um, and the developments since the last meeting is that the agency wants something much sooner than we previously um, had instructions about. So probably we need a slightly different process than the one we started last week, where we spent all, the whole hour on one sentence. Um, the good news, I think, is that we actually have quite a bit already in the document. I think the challenge is, you know, whether I don't know to the degree to which people have looked at it and have different opinions than what Nora and Ko had put in. Because essentially, our tasks are um, accept or reject the edits that Nora and Ko made originally, and I guess resolve the comments around them. And then there's the outstanding piece, which is the waiver standards and the JPAR and related standards.
Right.
And I think that might be I don't know. So I guess the question I have is, should we just start to more quickly go through the document, those of us who are here, or should we instead ask, or should I keep asking people to essentially make comments and then I should do some sort of resolving? And we should spend this time on um, talking about the waiver standards or the JPAR standards.
The waiver standards, it's something that Liz and we just need to set a formal time to do it. We had said, oh, we'll get together during the conference, but that was not realistic or going to happen.
But we do have a plan about how to approach it.
We do.
Do you think it's possible to get something in draft form by the end of August?
Yes.
Oh, yeah.
Yeah.
Great.
Yes. Yeah, totally.
Okay.
I thought you were going to say by the end of next week.
Right.
No. No, I mean, I think that the challenge is that we had originally kind of internally thought about a 6-month timeline for this overall project. And now they want something not in final form, but in final-ish form by the end of August, which is a little bit faster. And realistically, we only can get everyone together about once every 2 weeks, and it's probably even harder than usual during the summer. So that's only like 3 or 4 more meetings. So our process does need to be a little different. But if you all think it makes more sense to just start going through the document, since you all haven't had a chance to meet, okay, then I will pull it up if I can find where. There we go. Is that showing up for y'all?
Yeah, it's just
should be bigger.
I mean, I'm looking at it on my other screen, but
that. Okay, so we spent a lot of time last time on the discovery issue.
Right.
I think we, including making available and reviewing discovery material with client. I think that we mostly finished that. I think people felt comfortable with where we ended with that. So I'm gonna scroll down.
All right.
Kevin, were you waving or raising your hand or neither?
I was just waving. I didn't want to interrupt you.
Great. Number 5 here. We also have including reviewing all discovery with client. Making available and reviewing, including reviewing all discovery. I think the compromise we arrived at last time was the taking out the word all,
Hmm.
even though it was understood that generally all should be reviewed. But I think if that's where we landed on the one above, we should take it out here.
Sure.
I should say that I think we talked about last time that in the criminal, on the criminal side, I think where we landed is that the bold would be the black letter, and the what's currently phrased as implementation will be best practices.
Yeah.
And so I think that's the goal will be to align that. I think it doesn't, it's some of the what even on the criminal side is being called best practices are really more details about what should be black letter. Or it's like, almost like an explanation of the black letter, which I think this is often as well. But we're trying to phrase the standard to be more general, and then the implementation slash best practices to be either a little bit aspirational or detailed in a way that would mean that maybe not in every circumstance they would apply. I guess that could include the kind of all discovery example from above. So I guess that's the background, and I will go through at the end of this and try to make and see if the degree to which we've succeeded in that when we get to the end. Should I scroll slowly or read out the additions?
Where are we?
Sorry, we are
On 1.2?
We're on 1.2, and it looks like the addition, the big addition is to best practice implementation number 1, but staying current in the law. And then KO. Go ahead.
I feel like that's an appropriate addition there.
Yeah. Yeah. Okay, I'm going to just accept those.
And then there's a couple places where, I can't tell if she was taking out the practice of criminal, like a reference to criminal law and delinquency.
Yeah.
It was an unresolved question between KO and I, was whether or not to include criminal and delinquency or just delinquency, because what we were trying to prevent, which I think is sort of in the commentary, is like we didn't want attorneys that just practiced criminal law to be like, oh, I can just do delinquency law, no problem, it's fine, it's no different, it's just baby criminal law. We wanted to make sure, but we also didn't want lawyers that didn't know anything about criminal law to start to just jump right into delinquency law and say like, well, I've been representing kids in dependency cases, so I know all about kids, so delinquency is no different. So that the two practices are interconnected, but distinct. That makes sense?
I think it makes sense.
And we just didn't resolve it. How to word it. So here we are.
I feel like with some of the recent case law, we're getting more and more we're seeing a rise again of more of the criminal concepts.
Mm-hmm.
Like, consecutive sentences, sort of some dispositional issues about whether cases or counts can run consecutive or concurrent, and that may have an issue. So I feel like there's more and more sort of criminal
Overlap.
legal concepts that are coming up.
Yeah.
Um,
So then maybe we should say both.
so, I mean, I guess I'm sort of inclined to say both because
Mhm.
I don't know. Kevin, do you have
Yeah.
thoughts?
I think the reasoning behind it is clever, but I always want to make sure that more people are encouraged to come into the practice, I suppose. Especially, I guess, from the criminal side.
So where does that leave you?
I would fall into leaving them there.
Leaving
I
it as
mean, both criminal and delinquency. Do
Uh-huh.
you think that that is too exclusionary?
No, what we had been, I mean, the only thing KO and I had been batting back and forth was just wanting to make sure that there wasn't this idea that just having experience in criminal law meant that you didn't need to know anything specific about delinquency law.
Totally. Yeah, I get it, but I mean, I hate to say practically, but I've always found that the criminal defense attorneys who dip their toe, I think, do better than the dependency attorneys who dip their
Yeah,
toe.
I think that that's true.
I wonder if the answer to that question is maybe in implementation number 3, which says a lawyer practicing juvenile delinquency law should complete at least 10 hours of CLE training. And then criminal, and currently it says criminal and delinquency law each year. And I wonder if, I don't know, I mean, 10 hours of delinquency specific might be kind of challenging unless folks were doing out of state trainings, but to specify like at least 5 or 6 hours of delinquency focused training as well as specific criminal training.
Well, I think do we need to make it specific? Is the and sufficient since it's not an or?
Liz, are you trying to avoid people just taking 10 hours of criminal and calling it good?
Mm-hmm. Mm-hmm.
What if you use the term applicable?
I don't know if that makes it clearer.
I mean, people will just do 10 hours of criminal and be like, hey, I'm good, OPDC. What more do you want me to do?
That's what I do.
So, I mean, if we want people to have delinquency specific training, I think we have to say delinquency specific training.
I think even 5 hours of delinquency specific training is challenging under the current offerings.
I mean, maybe we say 3 hours of delinquency focused. I don't know. I mean, I'm just thinking that might be a place where we can sort of target folks' time.
Mm-hmm.
I mean, because I think the next one down talks about immigration, and I think I might have raised this. I can't remember who I talked to about it, but the mandate for 2 hours per year of CLE about immigration consequences seems unrealistic when, you know, the bar's focus is I have to be able to spot the issue, and then OPDC provides financial assistance so that I can get an actual immigration lawyer to provide me with real immigration law consults. And so we're just shifting, some number of hours that is delinquency focused. I mean, I think we should take the immigration requirement out personally.
Mm-hmm.
But I mean, I agree lawyers should be familiar with the, collateral consequences of delinquency adjudications, but I just don't think I don't think there should be an hour requirement
Mm-hmm.
of CLEs for immigration.
I tend to agree. Before we get to 4, do we want to resolve the wording in paragraph 2, though? I think we're getting ahead of ourselves. Do we want paragraph 2 to say criminal and delinquency or just delinquency?
I mean, I think it should say both.
I tend to agree. And then we need to resolve paragraph. I just want to not.
No, I get it. I think that, thinking about them informs the thoughts for me. Thinking about 3 and 4 sort of informs my thoughts about 2. And I think both words should be in sub 2. But then I think going into 3, if we want specific delinquency CLE training, I think we just put it in there and we cross out criminal and put delinquency there.
But we want them to have training in criminal as well.
Well, then we can put both. And
I think
Colin, have they decided how many, like what the requirement's going to be on the criminal side?
No.
Are they talking about it?
No, I mean, I'm trying to remember where this one is on the. It might just, they might just have taken out delinquency and left it at 10.
So like 10 hours of criminal per year?
Mm-hmm. Mm-hmm. I'm not positive about that.
Do we want, I mean, it's hard to imagine somebody who's delinquency qualified but not criminal qualified. Am I thinking wrong about that?
I can't think of very many. Just thinking about people who submit their qualifications. Usually,
Right.
It's rare that we see someone only check the delinquency box.
Right.
but it's possible. So I think just to recap, for 2, we're keeping criminal and delinquency in there.
Mm-hmm.
And for 3, I mean, we could say at least 10 hours of continuing legal education in criminal and delinquency, at least 3 hours of which is devoted to delinquency specific CLEs.
Yeah.
Okay. And then for immigration, we could take out,
Just take out the whole second sentence.
yes.
Yeah. And it actually says the possible immigration consequences of I guess it's already been deleted. Sorry.
Yeah. Okay, so then the next looks like there was a bunch of edits in paragraph 6 and 7.
Mm-hmm.
So
I think those were from me and KO.
yeah, so I think unless there's an objection, I like changing working or basic to working.
Mm-hmm.
And then looks like you added trauma,
Mm-hmm.
decision making, fight or flight response, and communication. and experts. Ups.
I wonder if that last sentence of paragraph 6 should be a standalone. It is kind of like mushed into paragraph 6 has a lot of stuff going on in it.
Mhm.
I actually agree with that. I think it would make more logical sense as a separate
Yeah.
one. It also adds some emphasis on
Mhm.
reaching out to experts and
Yeah,
that
I
should
don't
be
want it to be,
important.
yeah, I think that can be a standalone requirement.
Great. Oops. So now we're on new paragraph 8.
Mhm.
Used to be paragraph 7. That looks like beginning was just rephrased to acknowledge waiver.
Under what was sub 7, that last sentence, lawyers representing youth about the federal sight and sound restrictions.
Mhm.
Should that either be a separate one or should that fit into sub 9?
I think it connects to 7 because it is specific to youth who are being treated as adults.
Okay.
Because that's where it kind of arises.
Yeah.
Is when a youth is waived. Generally, that's when it arises, when youth are waived and
Right.
they want to house them with adults.
Right.
Yeah. So that's why, to me, it makes sense there. Although I feel like logically, maybe swapping 8 and 9 makes sense because we're sort of going through delinquency stuff, and then the last paragraph being representing youth who are waived. Just logically makes more sense to me as the way it reads.
And putting 9 in front of 8 after experts.
Correct. Or swapping, so putting after experts, putting the lawyer providing putting 9 after, just swapping 8 and 9. Yeah.
Does the stuff about not in what's currently 9 or about waiving, is the stuff about the impact of trauma on emotional and neurological development
Repetitive.
is it repetitive, and does it imply that is only needed for waived youth?
Oh,
And that's what I was just trying to think through. I think that's a good question. The sentence where it says must be familiar with adolescent brain development, impact of trauma on emotional and neurological development, and be trained in communicating with youth in a developmentally appropriate manner. I feel like that could actually go at the top of the section.
although it's
Because
also kind of addressed in 6.
Yeah, similar but not identical language.
So maybe
should we
if we swap,
wordsmith it into sub 6?
I think maybe take out the way that it's written in 6 and just put that language into 6.
Put into 6 must be familiar with adolescent brain development, impact of trauma, and trained in communicating with youth, because that should apply to everybody. Then take it out of 9.
I think the reason that we had put it into 9 was because 9 would apply also to just criminal lawyers who are representing youth after they have been waived, right?
So, but
And
really, I think you're right, or potentially right. I don't know why it was written there, but I've been thinking on the criminal side that we need to make sure similar language is in the criminal standards.
exactly.
For
Yeah,
waived youth.
because a lot of times after a youth is waived, well, not a lot of times, but sometimes a criminal attorney will step in, right, in place of the delinquency attorney. And we want to make sure that whatever criminal attorney is handling the youth's case in criminal court, that they have that same knowledge. And so that's why I think it appears twice, but
Well, I think wherever we put it, and I with that explanation, I think it could go in both places, but then I think the language should mirror each other. I don't think it should be separate
yes,
or
I agree.
different. So
Yeah, I think it should be the same.
And do we like the language in 9 better than 6?
I like the language in 9 better than in 6.
yep.
And then I guess the question is, do we leave it in 9 and hope that those criminal lawyers look at the delinquency standards, so we just make sure it's in the criminal standards? I mean, really,
do you have
they're
every like
Hey,
every
Matt.
hey, good morning. Sorry I'm late, everybody. I had something come up. I guess my question on in the criminal standards is everything listed, like every type of appointment situation, or is there just can you just reference the delinquency standards? Like, do you need to spell it out for each possible situation?
I guess say what you mean a little more. Like, I guess in the criminal standards currently, I think there's a reference to waived youth. I have to double check that. But are there other situations you're imagining?
I mean, not really. I mean, there are unusual situations that come up all the time. So I mean, I don't want to waste time, coming up with an example of, the interplay between, for instance, fitness to proceed and civil commitments, or where you might not be. I don't know. Well, I guess if it's referenced for the infrequency that it comes up, it seems like you could just reference the delinquency standards, but we're not talking about I guess, the criminal standards, so it doesn't really. It's neither here nor there. I was just wondering if we could streamline the situation.
Yeah, I mean, I guess there's no harm in having it in both places if we want to make sure people know what to do if they have a waived youth. So maybe that's the easiest answer for now. And if the commission objects when they're reading it, they can tell us to take it out.
And truthfully, the average 18 and 19-year-old client, a lawyer should know all of this anyway, because the 18 and 19-year-olds are just not that much different than the 17-year-olds.
Yeah. Did we decide I know we discussed the Sight and Sound. We currently left it in what's now 9.
I think it should stay there.
Sure.
I think it makes sense because that's who it's most applicable to is the waived youth. That's where it comes up the most.
So,
I mean, it can, I guess, technically come up pre-waiver if you're representing a youth who is over 18. While the waiver case is pending. There is some the Sight and Sound regulations are certainly less than clear about what happens to the youth in that situation. So a really aggressive jurisdiction. In fact, I had this happen in Baker where we had a whole back and forth about whether to transfer a youth to jail while the waiver case was pending. So maybe it should come out of just the lawyers representing youth who have been waived, and it could be a standalone. I don't know.
Maybe it should be a standalone. I mean, I think there have been issues around the state over the years where, the sheriffs are like, but what else? I mean, especially in some of the smaller jurisdictions, I think, and ever so often it's come up in Multnomah County when they start running out of room at detention. That it's been I mean, I don't remember hearing or having that issue in like 5 years, but I remember there have been
Oh, I know.
times in the past.
Yeah. I know Norcor won't hold a kid after age 18. Even if their case is still pending in juvenile court. Which is why it arose on my case. So.
Right. Well, and you add to that the changing contracts and different, kids from one jurisdiction being moved into other jurisdictions and things like that.
Yep.
Okay. Standalone. Looks like no substantive edits in 1.3. Or 2.1 until we get to sub 5 and 6. Everyone good with the talking to family about release plans addition? Then the lawyer should ensure that the client has all relevant orders as desired by the client.
Did we skip over 1.3?
Well, sorry, I only skipped it because there were no recommended changes originally. But if there's stuff you think should be changed.
No, sorry.
No problem. I'm just trying to move us along per agency request. Anyone have thoughts about giving clients the orders?
I think as long as it says, per client request.
Yeah.
Now we're on 2.2, and KO left the comment about making sure that the lawyer has to personally meet with the client. I can't tell from her comment if she's suggesting that as written it doesn't do that because the lawyers will interpret the word lawyer to include their team.
Yes, I think that's right. I think that's why that comment is there.
So add the word personally or something?
Yes. To personally conduct a client interview. I think that some people do have their investigator or their paralegal or their legal assistant go and meet with the client.
does adding
Well-
personally seem like that does address it, or that?
Yeah, I mean, I think so. I put my hand up more as exasperation that people would send somebody else to explain anything legally, to their client. That's not an attorney. So that wasn't raising my hand for a comment. That was just no idea. But yeah, personally works. I think it was clear before, but that makes it very clear, in my opinion.
Okay. Okay, I'm scrolling down. I don't see. So we're in 2.2. I don't see a ton of edits suggested by Ko and Nora. I don't know if other people have other ones. This is a long one about what should happen at that interview. So I guess there's a bunch of, or some suggestions in sub 6. So it's like mental health needs. I'm going to change re to regarding, at least for now.
That makes sense.
Descriptions of access to medication. Anyone have any concerns about the addition of the mental health needs? Okay. And then new sub 8 is information concerning client's arrest, including information regarding any searches or seizures, statements made to law enforcement, identification procedures, and circumstances of the alleged offense. It is ideal to obtain this information as close in time to the events as possible, as the client's memory may fade, etc., or be altered after reading the discovery.
Well, I have a question here. As a young lawyer, a very seasoned lawyer who did all of our training, very clearly his practice was to review the police reports with the client and then talk to the client about what happened. And Matt just raised his hand. So,
Yeah.
And
Agree.
the articulated
Agree.
reason, which, is, I want to give my client the best opportunity to describe their circumstances and what they recall, in a way that could be helpful to their defense. I know, and I've worked with people who will go in and immediately ask the client what happened, and I have never done that. And I don't know if that, I appreciate that, client memories fade, and evolve over time. But I have trouble with the second half of that sentence.
Yeah, that was my reaction to it. I was wondering if the circumstances of the alleged offense, we just take out that part, because it is important to know about the other things, ideally as close in time as possible. That's still
Sure.
true. And then maybe take out and the circumstances of the alleged offense, and then later take out or maybe altered after reading discovery.
Sure.
Yeah.
Like that, and then it is ideal to obtain it. And then, well, I guess as client's memory may fade with time, and then period.
I mean, I think that's fine to stay in, because that sort of adds the aspect of urgency that a lawyer, as soon as you can get in and start this process with them. I think that's very reasonable.
Does that work?
Yep.
Okay. And then I assume we want to keep in video evidence and other things that need to be preserved.
Mm-hmm.
Right.
That edition. Okay. Now we're in. No, I don't know what. Oh, this is, I guess, B. Yeah, sub B, part 2, including exceptions to the privilege was added. That seems reasonable. And now we've added sub 6, discussion of who the client would like the lawyer to communicate with and what limits about the type of information that should be shared. I see nods, so I will accept.
I think that's really important.
Yeah.
It's arguably one of the trickiest parts of practicing delinquency law is dealing with specifically parents, but other interested family members, and
Mhm.
their view that this is he's only a 15-year-old or whatever. You hear that all the time.
Yeah.
But it's very clear that you need to really set boundaries and make sure everyone's on the same page of who's in what role, and you really need to explain it to your client, because I think most clients are like, well, of course you can talk to my parents. And I think you really need to explain what that looks like, what that means, what
Mhm.
what limits you would like, what we can place on that, and they might want to, for whatever reason. I think you sometimes have to explain that to the parents completely separately, just sort of in the abstract of why that is too. And I don't know if that's in there. I can double check. But
Yeah, that's a good reminder to look out for that. I don't remember seeing that, but I haven't looked down all the way recently.
I wonder if somewhere in here we shouldn't put some implementation of, communication with caregivers or parents, or lawyers shall, consult with client before communication with caregivers or parents, or something like that, just because it is one of the most complicated aspects. Because we do get domestic violence cases where you represent the kid who hit mom or something else. And it's often that they're victims one way or the other. Sorry, I'm sorry, I talked over you.
it's okay. Parents often have different interests than their kids too, and
Yeah.
what the outcome of a case should be.
Yeah. Okay, I put that comment in, and I guess I'll just look out for it as we keep going, and then circle back if we need to add it in. Bunch of stuff was added into sub 7. Use any contact to gather information, including circumstances around any statement, threats or promises, any evidence. That seems a little repetitive to this one. What was this one about? During an initial interview. Okay, so that before we were at an initial interview, and now this is saying any contact should be an opportunity to gain essentially these same things.
I mean, what we're trying to say here is you have a continuing obligation to work the case.
Yeah.
Mhm.
I don't know if it's overkill to list everything that you have to do
Yeah.
again.
Right.
I don't know if we need to list everything. The one thing in here that I do think we should remind folks of is there's a constant assessment or reassessment of clients' competency.
That's in there.
It is in there. I would like that's like I don't
Yeah.
think that's repetitive. I think it should be in there because that's
Mhm.
Especially if as your kid ages and or if they come in and they're loaded, you often don't sort of see what their sort of actual competency level is until they've sort of stabilized in detention.
Mhm.
it just can be so fluid.
So do we want to leave in all the other stuff, or do we want to pare this down to the highlights, or rephrase
Well-
in some other way?
Should some of this be added into the initial interview, or because it looks like, Nora, you wrote a comment about information concerning client's history that would impact social and emotional and neurological development, and whether a client's trauma history and or brain development impacted client's actions or thought processes. Do we have that up in the initial interview? And if we do we need to repeat it?
I do not.
In the initial, it says mental health history, special ed history, medical history, but not as specific. Looks
Right.
like. So should we put what Nora had suggested up in the original one, or in the
I
initial
like
interview
that.
one?
I wonder if sub 7 shouldn't say, or whatever it is numbered now, if something, it shouldn't be, lawyer should use any contact, and then under one of the subs should be something to the effect of continuing to obtain the information described in
Hmm.
6A or 6B or whatever it is. Because, one jail visit or one meeting with a kid, that's a whole lot of stuff to get out of them. And their attention spans just aren't that open sometimes, or makes it really hard. So it really is sort of an ongoing process. I like that idea. So
So I'll figure out a way to add that in. Are there things other than saying go back and look at what's in 6 and keep doing that, and the competence? Is there anything else you want to pull out specifically?
I pull out, do you mean delete or
Sorry,
put somewhere else?
I meant I guess I meant in this context I meant leave in.
I
Like
see.
is there a reason, like in some ways police threats, like that should also be in 6, and
Mhm.
you should always know about it. Like there's not a reason it would not be. But I
During
guess
the initial interview.
yes,
But
I guess this number 7 isn't necessarily saying this isn't the first one. It's just
Right.
saying any contact.
right.
And the sub 6 was specifically the first contact.
Right.
But it's a weird distinction to think about, sort of. But witnesses, for example, that was definitely in 6, right? So is there a reason we pull it out and say you should talk about that every time? If you were also saying go back and do the things in 6?
Yeah, I think if we're saying go back and do the things in 6, then we don't need to relist them, because
Yeah.
then it's just cross-referenced.
Yeah. So that's evidence and witnesses and whether they were under the influence. I think that's a repeat too. And we already added their neurological.
Yeah.
So maybe it's just do the things in 6 and make sure they're competent.
Continue to review and discuss, yeah, the topics outlined in 6.
Okay, I'll go back and do that. No, we are at 10 o'clock, and I know y'all are busy. So I will make some of those changes, and I will send out another poll, and we made it all the way to page 8. Much farther than
Amazing.
last time. Thank you all.
Okay. Colin, when you send out the new whatever we do, can you add a link to the updated the link to the Dropbox document?
Yeah.
Thank you.
Yeah, will do.
Uh,
Thank you. Any
I gotta
other?
go.
Okay.
Yeah.
If anyone
Thank you
has
all.
requests for polling times that I haven't been including, let me know.
Okay. Thank you.
Thanks. Bye.